Okay, thank you very much, Shauna. That was excellent. So my presentation is on how lawyers can avoid pitfalls by spotting things before closing. And just about my whole presentation is based on real fact scenarios that we've seen come in, that our claims department has seen. And the claims have been covered and dealt with, or else we're in the process of dealing with them. But these are the kinds of things that lawyers should look out for and can prevent. This isn't a comprehensive selection, but it's the best sample I could call based on a number of claims that we reviewed to prepare the presentation. And again, I want to reiterate what Shauna said, that each claim that comes in is considered on its own individual facts and with reference to the individual applicable policy. So in general, the chain of events with these things is that the deal closes and the title insurance policy is issued. And then what happens is at some point after closing, maybe soon after, but unfortunately sometimes a long time after, years and years, it will be discovered that there's a problem. The proof of loss is submitted and a decision that it's a covered claim is made by our claims department. In this case, as you'll see from the examples I'll give, the client's expectations for the transaction in general are not met. All the examples I'll give were covered by our title insurance policy, but the clients are considerably inconvenienced and put out, and I will say in most cases disappointed. So that is a factor to consider as well. Also, even with the best will in the world, repairs take time. Third parties may be involved. We may have to negotiate with neighbors, the municipality, for example, and none of those people need to move particularly swiftly. So that can be frustrating for the client too. If a lawyer does become aware of problems before closing, the way to deal with it is to call in or request an insure over in your application, and an underwriter will be in touch with you. For a lot of types of problems, we can provide substantial help. For instance, if there's an encroachment that you're aware of, very often we can give full marketability coverage for the lender and forced removal coverage for the purchaser. And before I start the specific claims examples, I want to advise you of one thing that's quite important, and this is a general caution. It's important to identify and address problems before closing. Make sure you know what the client thinks they're buying. They may have expectations you're not aware of. Ask the client what kind of property it is, what is the present use, because as a rule, the agreement of purchase and sale only provides that the present use can be lawfully continued, as you know, and what do they intend to use the property for? If it's a house now and there's no office use and they want to use part of it as a home office, that's a change of use. If it's important to them to be able to build an addition, then that obviously is a build or a renovation, and no changes of use and build and renovations, as Sean also pointed out, are not covered under any title insurance policy. For TitlePLUS policies, if your client intends to do something the property is not presently used for, you can request a future use endorsement, and an underwriter will advise you of the charge and of any additional searches that you need to do. But remember that that is not covered by your standard title insurance policy. So this is where I've begun with the claims examples. So here's the first one. The lawyer acted on the purchase of 2 abutting townhouses. They were described as parts on a reference plan. And it was a resale. When the builder had transferred them, there was a part lot control exemption bylaw registered on the title. But unfortunately, it specified an expiry date. Many of them do. The lawyer didn't read the part lot control exemption bylaw, which would have disclosed that. They were abutting properties and the client took title in the same name. Later on, the client decided they wanted to sell them separately, and it was realized they couldn't do that because it was a contravention of Section 50 of the Planning Act. So the client was not too happy about this. A claim came in, and the repair that we undertook was to go to the municipal council and get an extension of the date on that part lot control exemption bylaw. But that took some time. Obviously, these things do. To avoid that, especially if your client is buying two abutting parcels that are not whole lots on a plan, pull and read that part lot control exemption bylaw, make sure it hasn't expired, and warn your client that if it has expired or if there is no such bylaw on title, those parcels are going to merge and they will not be able to sell them separately without getting a fresh consent or an extension of the bylaw, because the client probably will want to sell them separately. Another possible solution would be to advise the client to take title to the two abutting properties in different names. Okay, here's another one. This was a purchase of a resale condominium. Then the purchase and sale provided that the client was buying a dwelling unit and a locker unit. It didn't specify the unit number. The status certificate that was obtained and came with the agreement of purchase and sale didn't include any reference to the locker unit. And in fact, it appears that the lawyer didn't even notice that a locker unit was supposed to be part of this deal, and on closing, the client didn't get title to that locker unit. Afterwards, it came to light that the client didn't have a locker space to store their stuff in, and it was necessary for us to go back and get a transfer of that locker unit from the vendor. If time has elapsed between the closing and the fact that this actually comes to the light of day, then this can be problematic. This one wasn't only about a year ago, so that wasn't too bad. We were able to get it. It does get more involved, though. A couple of twists on this situation. Here's another one. The agreement of purchase and sale specified a condo, parking, and locker unit. However, as when we investigated, we found that the transfer to these clients and the previous transfer had erroneously not included the parking and locker units. Now, the people that owned them had been using them, but they didn't own them. In fact, you had to go back on title to 1998 to come to a transfer where they were actually all included. And no one had noticed till the third time it changed hands after that. If the lawyer for the client here had noticed that they were supposed to get title to those two ancillary units, as well as the dwelling, they could have requisitioned that, and the problem would have come to light, could have been dealt with before closing. As it happened, after closing, when this was found out, it was necessary for our claims department to go back to the 1998 owners, who were still the registered owners of these two extra units, and get the title from them. So that was a bit of trouble. Here's another one, somewhat similar. This was not a condo. It was a freehold property. The property comprised two pins. One pin had two whole lots on a plan. The second was part of a lot on a plan that was adjacent, and it was one whole property. It should have all gone together. However, the agreement of purchase and sale and the transfer and mortgage only included the first pin, leaving out this bit that was in the second pin that was a part lot adjacent. So that's a little different from the condo deals I described. The error was discovered sometime after closing when the vendor suddenly received a tax bill for the remaining lands and said, "What's this?" So a claim was reported, and we're undertaking the repair now. We'll have to register a transfer to the clients of the second pin. We'll have to put on a new charge or amend the existing charge, probably discharge the old one, probably just replace it. In this case, if the lawyer had realized the extent of the property that was being conveyed and that the clients expected to receive, if there was a survey, they could have noticed it from that, or if they looked at the registered plan, they might have noted it, or if they had searched by vendor name in that jurisdiction, the additional PIN would have come up and they would have been able to ask the client, is this bit of property part of what you viewed and want to purchase? So care needs to be exercised, and it's important to know about the property your client means to get. So as I said, the repair was involved because it involved the mortgage as well as the transfer. The next one I want to talk about is an access issue. In this case, in 2011, a house that was on the waterfront was the subject of the transaction. It didn't have frontage on a public roadway. There was one close by, but the way it was actually accessed was over several adjacent privately owned properties. And there was no registered right-of-way or easement, so no legal entitlement to that. It had been used like that for a long time, of course, and a problem arose after closing when somebody challenged their ability to use this private laneway. And obviously, if you can't access the property, that's going to detrimentally affect the value and inconvenience the people. So after investigation, we think that it may be that a prescriptive easement was established before the property got converted from registry to land titles. There was a sale of the property pending. It had to be terminated. The deposit was returned. We're repairing the situation. We're bringing a court application to declare that there is a prescriptive easement. We're hopeful that we can get that declaration, but we cannot be positive. And if it doesn't succeed, we'll pay the cost of the application and the difference in value, which I think will be substantial without access. But I don't think that's going to happen. I think the people can have their access. The next one is a little different. This vendor owned a farm and a house across the road. The client agreed to buy the house, but not the farm, so no problem with the Planning Act, at least in this one. But in error, the farm, not the house property, was transferred to the purchaser. And this came to light later on when somebody was looking at dealing with the farm. And it was realized they were occupying the house but didn't have title to it, but instead they owned the farm across the road. So we looked into the title when the claim was received. The farm property was owned by A and B as joint tenants. The other property was owned by A alone, and they had passed away in the meantime, so their estate was involved before we could fix it all up. And that made the repair more complex, as you can appreciate. So it's important, again, to know what your client means to buy, that what the purchase of the property is, what the property actually is supposed to do for them. Look at the plans, look at the PIN map, look at the legal description. Try and make sure that your client's getting what they're bargained for in the first place. And I want to add, I have seen claims with a slightly different fact scenario. I didn't put it in the presentation, but something also happens where the vendor owns more than one property. The purchaser is supposed to get title to one out of the two, but in error, both of them are transferred. And the purchaser ends up with more than they bargained for. And then, of course, later on down the line, that dealing is attempted with the second property that the vendor doesn't think they sold, and they found they have transferred it. So then you have to go to work to get the property transferred back, the mortgage discharged off and replaced on the right property. Next one is a little different. This happened to be a condo purchase, a new condo purchase. We found errors in names occur the most with builder deals, certainly not exclusively, but more often. The purchaser's name had been entered in reverse, and that was how it was registered. The lawyer never noticed it at the time of closing. There's an obvious caution here. Look at the draft transfer. Make sure your client's name is correct. If you're in doubt about how they want to take title, check with them. This was discovered shortly after the closing, so that was good. It was relatively easy to fix. But keep in mind that no one could have noticed until many years after, and it could be much more cumbersome to fix it. In this case, we registered an application to change the name of the owner, and the error was corrected. Remember also that if there's errors made like this, and it waits many years, it may be that there will be executions perhaps that supervene against the title holder. If they should have transferred the title but they didn't, the executions have since attached to their interest in the land, and even if you go back and try to get a transfer from them, the execution will rank ahead. So that can be a problem. The more time elapses, the more chance there is of something like that jumping in, so to speak. Okay, next one. The lender's instructions are sometimes a problem. This was a deal where there was a mortgage to quite a large bank lender, a very large bank lender. The lender name in the registered mortgage was one of the names that the bank carries on business under, but it was not the one that they had wanted it registered in as per their instructions. When we looked at the facts, it disclosed that, in fact, they had faxed instructions to the lawyer, and that one had the old name. However, the online instructions that they sent the lawyer a link to had the new name. So it was not consistent, obviously, and the lawyer should have been in touch with the bank, the local branch, to try and find out which one they actually wanted it registered in. But no one noticed, and so the deal went forward in that way, and it was caught afterwards, and the correction was made. The trouble with this kind of thing is, suppose that had not been caught, and suppose a few years later the mortgage went into default. Then the bank cannot enforce it, I suppose, the way they would have liked to because of the error in registering the name. Okay. In this case, there was an estate sale of a property. It was in land titles absolute. That is, it had never been in registry at all. It had not been converted. And in this case, neither the purchasers nor the vendor's solicitor caught that you could not use the first dealings exemption, because that only applies to land titles conversion qualified properties. And so they did not obtain a certificate of appointment with a will, otherwise known as probate, which is much shorter, but an old-fashioned term. And what they did do, they just registered a transmission by personal representative. They transferred the property from the estate trustees to the beneficiary, and the beneficiary mortgaged the land, and the transaction closed in that way. And then the land registry office kicked it back, saying you're not entitled to use the first dealings exception for this because it's land titles absolute. You must get the certificate of appointment, which the lawyer then went back and did. Fortunately, was able to do that in fairly short order, and now the transfer has been properly registered. Here's another one. This seems obvious, and actually I guess I should have put up a picture of the parcel register. But in this case, the lawyer simply missed an outstanding registration on title. There was an old certificate of pending litigation on that title. I remember looking at the PIN, and there were several deleted items, and then squashed underneath, but not deleted. It just said 1994, whatever date, and it said certificate. Nothing more, no clue what it was, but it hadn't been deleted. It was discovered many years later when someone searched the title so the clients could refinance. And we're trying to deal with it now. We investigated it related to litigation involving the neighboring property. We're not quite sure why it was registered on this property. Litigation was settled, but it was discharged off the neighboring property, but not this one. And now the land registry office is requiring a court order, so we'll have to go to court and get that order removing it from this title. Okay. Priorities problems. Dates are really important. This was a purchase under a power of sale, and there was a notice of security interest for a furnace registered, and it was registered ahead of the mortgage that the power of sale was exercised under. So because of that, it wasn't cut out under the power of sale at all. It wasn't deleted from title. It remained on title. The vendor's lawyer gave an undertaking to remove it, thinking it was an error and it should have been cut out, but they would not rule it off title for that reason. Title is still subject to it, and we're going to have to negotiate with the holder of the notice of security interest to see if we can get it off and how much it'll cost us to do that. Here's a slightly different one again. The thumbnail description is important. If you see a notation something like this, subject to the rights of owners of adjoining parcels, or subject to rights under, and then there's a reference to an old instrument number, usually a registry instrument number, as you see here. Don't assume that it's an easement or other possibly acceptable or innocuous registration. In this case, the lawyer made that assumption, and that's what they told the client, so the client went ahead and closed the deal. The client, a couple of years later, agreed to sell the property, got a requisition to remove this. The claim came in. When we looked into it, it turned out that it was much more complex. It wasn't an easement at all. And we would require a reference plan in order to get this deleted. They would just not take a straight application to delete it from title. So the deal closed. The vendor had to hold back $5,000 to cover the cost of that. We have paid that cost, and we are looking after getting that subject to notation deleted to satisfy that requisition. Those are all I have. I was tempted to put in lots more with all kinds of other horror stories and errors, but I thought that was enough for one afternoon. And now I would be very happy to take questions. Okay, well, thank you very much for your attention. Thank you for attending in person or by webcast, and have a good day.